ladies and gentlemen, expressly mandated by our...
There is a major fundamental issue that arises today, actually. Now, I cannot say, many Muslims view this as a Sharia offenses. And they have been living with these Sharia offenses for decades and decades, and they cannot see why there is an objection. Now, what is happening is that from the opponent is saying it affects non-Muslim. For example, the case of one-to-one. But I have to say this, from the Muslim point of view, one-to-one case, Subhashini case, and a number of cases has nothing to do with the Sharia offenses.
Ladies and gentlemen.
Right? Subhashini cases and many other cases are because of the separate jurisdiction of civil and criminal jurisdiction. Sharia offenses has been the same since Merdeka, right? To say that the Sharia offenses affect non-Muslim is incorrect. It cannot be and it will never be. Sharia courts are only for Muslims. That is why what is happening in our country, there is a big misconception again. From the non-Muslim sides, they think that this will affect them. But from the Muslim side, is actually saying, why are you objecting? Because it is not possible to affect the non-Muslims. Right? And there is where we are clashing again. Right? So these are some of the issues from my perspective.
Nobody ever said that the federal constitution is colonial. Nobody said. The federal constitution is colonial, then it is impossible for me to accept that it is the supreme law of the federation. Nobody is saying that it is colonial. What I am saying is simply that there is a problem where there is the trend among lawyers trying to import colonial ideologies into this law, which shouldn't be the case. What we are proposing in RUU 355 is not something new. The Act has been there since 1960, even before Merdeka. But after Merdeka, it was there in such a form in 1965, and then amended in 1984, and then further applied to Sabah and Sarawak in 1989. No big fuss. What we are asking now is simply for a further improvement. That is all. The Muslims in this country has been subjected to the civil laws. We do not complain. I'm not complaining. The civil law, particularly the penal code, is the laws that were imported. Basically, it is imported from India. The principles from India, which in turn were taken from the British legal system, which in turn are based, some are based on the principle of morality under the Christian principle. That is why we have section 377, offenses against bestiality, incest, and so on. We never complained. The Muslims never complained. What I mean is, we never complained that the laws were based on a religion that is not theirs. We never complained. Now, RUU 355, what we want to do is that we want to legislate the principle of morality of our religion, and we do not even want to impose it upon the non-Muslims. It is only among the Muslims. And yet, there are so much opposition. So, all I'm calling is this. We should get back to the provisions of the Federal Constitution. The positive obligation that I mentioned just now. We should not shut any doors to the improvisation of the Sharia court, of the Sharia system. Because the principle of Islamic law is very much embedded from the history as well as in our Federal Constitution. So, that is all that I'm asking.
The point is, by all means, you want to pass legislation. My only point is, do it according to the Federal Constitution. That's it. Just that. Okay? You have a view about whether it's constitutional. I think it's not because it brings in some of the hudud offenses. When it does that, it cannot be constitutional. That's my view, and that's the basis of my argument. But quite apart from that, I've given other reasons why it should be reconsidered. What I'm saying is reconsidered, because, as I say, it's very frightening when you don't actually know which are the offences that are related to that. And also, the increase is not double or triple, it's huge. So people are concerned about that, and I think they have a right to be. Now, I want to finish with this. Really, I think at the end of the day, you have to allow for differences in opinion. Because it doesn't accord with yours, you can't get angry, okay? Because I'll tell you, if you say it's democratic right of the states to pass legislation, well, courts actually can declare it null and void, because Article 76 allows that. If the state law doesn't comply with the Constitution or offends the federal law, it can be declared null and void. What I'm saying is, don't go through all that. Even before you get to the stage where it may be declared null and void, make sure it complies. That's what I'm trying to say. So I'm not stopping anybody's democratic right. I'll be the last person to do that. And I think really at the end of the day, and I want to finish with this. For me, actually, God is perfect. I mean, I believe in God. God is perfect, but man isn't. And the legislation is man-made. So we need to be responsible. When we go to Parliament, there's a duty on us to actually do things, properly. Yes, I'm not an expert. The gentleman said, of course I'm not an expert, but I know about law. I'm not an expert on the religion, but I know something about the law. I may be wrong, but I'm prepared to go to court and get tested. That's my job. And I'll finish with this, and I hope you don't object to my reading. I've seen such beautiful passages about justice in the Quran, and I am going to read 2 of them, and there's so many actually, all over, which talks about compassion, justice, and this is what I picked up. Behold, God enjoins justice and the doing of good and generosity towards one's fellow men, and He forbids all that is shameful and all that runs counter to reason, as well as envy. And He exhorts you repeatedly so that you might bear all this in mind. And I'll finish with this, another sentence here. Be just. This is closest to being God conscious. And remain conscious of God. Verily, God is aware of all that you do.
She had the right to go to the Sharia court. Now understand this. Article 11.1 of the Federal Constitution, this is the precise language. Every person has the right to profess and practice. Now, Jamaluddin Osman in 1987-88 no longer professed and practiced, and nobody questioned his right to renounce. Lina Joy's case, she already swore statutory declarations to say she no longer professed and practiced. Now, where was the written law that had changed from Jamaluddin to Lina Joy that now required her to go to the Sharia court to get an exit order? Because this is very fundamental. In 9th schedule, second list, item 1, Sharia court only has jurisdiction over persons professing. See the language, professing. Lina Joy was no longer professing. So how could she go before the Sharia court and ask for an exit order unless we were trying to expand the jurisdiction of the Sharia court without amending the written law? Now, this is a concern. So when I look at RUU 355, I see it in the context of an incremental encroachment of private space. All right? And I see it in its totality and not just RUU 355 in isolation. Just one last point. I think it's easy for us to throw figures about here by saying the majority feel this way and, back and forth. I'm so sorry. I do not profess to speak on behalf of any Muslims. I speak on behalf of myself. You guys speak up for yourself. Thank you.